All right, welcome to our public meeting of the Retirement System Investment Commission of August 25th, 2014. Glad to see all these smiling faces. First order of business is to call to order in our consent agenda at 11 o'clock. And I think Mr. Clancy
Yes.
has his statement.
Thank you, Mr. Chairman. Before we ask for adoption of the proposed agenda, one bit of housekeeping. Any minute now, you may hear noises coming out of the speaker system. The City of Columbia Fire Department is conducting tests in other parts of the building on the alarm system. We are told that it should not impact our floor in any way, shape, or form, but you may hear an announcement any second now, followed by an announcement 15 to 20 minutes hence, okay? We don't need to vacate the premises.
Thank you.
All right.
All right, may I have a motion, please, to adoption of the proposed agenda?
So moved. Oh, sorry. There you go. Alan, there you go.
I'll second.
All right.
I have some questions, please. On the executive session, what topics are we going to discuss? There were a couple that were emailed to us, but I'm not sure that those require us to go to an executive session. So can you shed a little light on that, please?
Yes, Mr. Treasurer, I think the initial discussion of the governance policies, which is one of the items, would be appropriate for closed session. It involves personnel, so I believe that's appropriate for that discussion to be involved in the closed session. To the extent that discussion on the action on the governance policies is appropriate, we'll take that into open session. But initially, I believe it's appropriate to discuss those in the closed session.
So is that the only topic?
You know, I think that was what you referenced in your email, and again, in addition to the personnel topic, he had comments on, I guess, your first 5 or 6 weeks in office. Was that what you had said?
I was going to give you a little briefing on some of the discussions that Rebecca and I have had with staff, just to give you a little overview.
Thank you. I find myself in the Jim Powers camp, which is we should never go into executive session because every time we do, we never discuss what we actually go in to discuss. And I would just, I would like not to go into executive session. I think the governance policies aren't person specific. They're just about the public policies and the governance policies of a public body. And I don't see why we should be in executive session.
Well, I think the other matter that is personnel related and does require executive session.
Well, they don't require executive session. We can do executive session, but if we're about to hire somebody for a significant job of public trust that's not even been open to the public, that's not been allowed to be discussed, I believe that we should have it in an open session.
Well, since it's I think following our procedure that we've always followed in the past, when we've discussed candidates for these positions, we have discussed them in executive session and then brought it into open session for a vote, and I see no reason to change that procedure today.
Well, what would can we then at least change 4 to go 4-3, so we can discuss the person then, but about the expectations in the hiring process? I mean, we've got the cart before the horse.
I'm not sure that I would agree with that. I think probably going into executive session to discuss the personnel and receive legal advice on the process would be, I guess, more efficient than actually trying to discuss something in open session where we haven't had the personnel discuss the personnel or actually receive the legal advice on it.
Is the legal advice significant? I mean, because we know we can hire and fire at will. I mean, what would we be discussing?
I think it would be, yeah.
Excuse me, Chair.
Yes.
And we did just want to clarify that no votes will be taken in executive session.
Yeah,
Well,
that's-
all right,
that's
I mean, I'm
okay.
obviously gonna, we know how the vote will turn out here. Let me just say this. This is a matter of importance to the people of this state. Hundreds of thousands of people are members of the retirement system and pay into the system. We're gonna be having what is a significant event for them in executive session. We can go into executive session, but we don't have to. I think it's an error. I don't think we should be hiring people without, jobs being open. I don't think we should hire people without searches and all these things. And of course, this will be taken care of in executive session. It's just wrong. We ought not to do it. The public has a right to know.
Well, we will have that discussion in executive session. We will then come into open session, and presumably we'll take a vote. And if there's any further discussion at that point, Mr. Treasurer, we would certainly allow that. So may we have a vote on the adoption of the agenda?
Can I just clarify, so I understand, executive sessions for purposes of the governance policies and personnel and legal?
The two stated bases
Yeah.
are.
Governance policies as they relate to personnel.
As it relate, right.
Any other questions? If not, I call the question.
Well, I guess, the one other thing, I guess, were you proposing that as an amendment to the agenda?
Well, I mean, I would like to.
So we need to vote on that issue, right, and then vote on the agenda itself?
Yeah,
Is that
I
right?
was about to say we shouldn't just for time's sake, because we know how the vote will come out. But yeah, let me, I would like to propose an agenda, amendment to the, agenda, and that is that we do not go to executive session for these issues, as I don't believe that they were required, and that we, in any event, would, reverse the order and have item number 4, the expectations and what the hiring process will be about, before we have the conversation about the person we're gonna hire.
I'll second that motion.
Any discussion? All right. All in favor of the motion? Opposed?
No.
No.
Nay.
It's 4-2. Okay, motion failed.
The motion fails. And the agenda is adopted as proposed.
Well, now we need to vote on the agenda itself, right?
Okay.
Oh,
The original.
yeah, okay. Do I have the,
All in favor? Yeah, we already have the motions.
all right, so all in favor?
Aye.
Motion carries.
Were there any votes in opposition? Thank you, sir.
We can move on to funding of the, we'll move on to item 2, funding of State Street Global Advisors. And I think, let's see, we have a motion.
So that we can get the discussion started, I've read the motion that's been posted to Watchdocs, and I would move.
Is there a second?
I second.
All in favor?
Discussion?
Any what? Any
Yeah,
discussion?
we'd like to have a lot of discussion. We're gonna drag these things through.
So,
Yep. I'm sorry.
Yeah, it can be read, I would think.
Does everybody have a copy?
I think you should all have a copy.
But can we read it for the public, right? I mean,
Well,
it's-
If you would, yes, we can.
I
have
think
it.
we should.
All right.
Right.
Betsy or Robert, would you like to read that?
Sure. We'll take your copy in the meantime. And then Ms. Byrne was going to hit on a number of these, a number of the topics, the facts of the matter. The motion, however, is, it should, first of all, be in your packets. You should have access to it. We can try to get it up on the screen. That would be useful. Yeah, thank you very much. That would be very helpful. It's in the open session motions packet. All right, the motion states as follows: whereas the commission unanimously approved an investment into SSGA's passively managed Global Equity Index Fund on September 26, 2013, so quite a number of months ago. Whereas RSIC Legal executed a certification of legal sufficiency on July 25th, 2014, and the commission mandated 3 business day review period for this investment commenced on July 28th of this year and ended at 5 p.m. on July 30th of this year. And whereas the chairman granted the treasurer an extension to the review period until 5 p.m. on August 1st of this year to raise specific questions or concerns. And whereas the treasurer at 4:59 p.m. on August 1st, 2014, emailed the chairman to state that, quote, "The state treasurer is unable to make determinations needed to fund the State Street investment, period, until such time as the information is available and in a format accessible to the state treasurer. Fundings will not be possible," close quote, without raising any specific questions regarding the investment. And whereas the 3 business day review period as extended expired after due and proper notice to the commissioners, and whereas on August 1st, 2014, after receipt of the closing certification from RSIC counsel and upon consultation with RSIC legal, the chairman of the commission authorized the execution of the required documents, and this investment was fully closed on August 4, 2014. And whereas RSIC staff and council have attempted since August 1st to ascertain the exact nature of any concerns or specific information needed by the treasurer that his office had not previously been provided, including following up by email several times, an in-person meeting with the treasurer's staff, offering edits to the certification of legal sufficiency requested by the treasurer's staff, offering to draft a designation letter, so-called designation letter, to State Street, purpose of which is to assure the treasurer that Bank of New York Mellon would receive certain information regarding the investment, and providing information requested by the treasurer's office regarding contacts by Conifer Financial Services with the trust fund's investment managers. And whereas RSIC staff, in order to begin the in-kind funding process, and this is after August 1st, liquidated securities to raise cash in the amount of $1 billion in anticipation of funding the investment. That work was done as of August 12th of 2014. And whereas as of August 21st, that was the date in which the motions were provided to you all, as of August 21st, the treasurer had refused to authorize the directive to transfer that $1 billion in trust fund cash to the Russell Global Equity Transition Account so that this cash can be converted into securities. And whereas as a result of the treasurer's refusal to execute this directive, and as a result of the extremely low interest rates available for cash, the trust funds are missing out on approximately 0.50%, so that's half of 1% of income, compared to the income that the trust funds had been receiving on the previously liquidated securities on an annualized basis. And that equates to an average loss of income for the trust funds of $13,700 per day. And whereas, because the cash is now currently blocked from an internal transfer between the trust fund's accounts at Boney Mellon to fund the purchase of physical securities, the trust funds are missing out as well on certain favorable tax benefits on the non-U.S. holdings in an approximate amount of 0.175% of annual reclaimable dividend withholding taxes, which equates to a loss, an opportunity loss of approximately $4,800 per day. And whereas the sum of these two sources of lost opportunity costs is approximately $18,500 per day, and whereas the Treasurer's Office has failed to respond to RSIC staff to articulate any remaining questions or concerns regarding the investment that relate to the Treasurer's custodial function, now therefore, the South Carolina Retirement System Investment Commission directs the State Treasurer of South Carolina as the statutory custodian, pardon me, of the funds of the South Carolina Retirement System Trust Funds to execute, number one, execute the trust fund's duly authorized and completed directive to Bank of New York Mellon to permit the movement of $1 billion of the trust fund's cash to the Russell Global Equity Transition Account to fund the purchase of physical securities as outlined in the trust fund's directive. And number two, upon Russell's purchase of the necessary securities, to authorize and execute the trust fund's directive to Bank of New York Mellon to transfer those securities from the Russell Global Equity Transition Account to the SSGA MSCI World Index Non-Lending Fund. That, Mr. Chairman, is the full text of the motion that was distributed to the commissioners late last week. Ms. Byrne, did you have any other things you wanted to mention?
I did. I won't obviously read, that contained a synopsis of the process, and I've got, you know, the very detailed correspondence back and forth, but I don't think we need to go into that now. But I did just want to add a little additional color in terms of the discussions that we've had with the staff.
Well, let's hold on for a minute. This is a commission meeting, the commissioners don't have to talk here. You've got staff who's been driving this process, and staff has written this, and so I'd like to say a few things here first.
Why don't we
Mr. Chairman,
let
Mr. Chairman, I
Mrs.
think
Burns
we may-
finish her statement? You interrupted her, let her finish,
to it
and then
first.
you may proceed. Mrs. Burns, would you please
I
continue?
believe
Reynolds, I'm
Commissioner
sorry,
Logan
did you say something?
I move that we
What's
pass this,
Ms. Burns?
I make the
But,
motion. that we
Mr.
vote.
Treasurer, you are out of order.
I'd like to speak to it first, please.
Now, we will proceed in order, and we're not gonna have a lot of disruption or interruption.
We're not.
All right, now you're interrupting. Now, would you like to be, would you like to be recognized, Mr.
Doesn't a
Treasurer?
vote take precedence?
Yeah, call the question. take
I call the
precedence,
question.
We need to,
You call the question, you got a second.
call the question,
Got a
so we gotta
vote.
react to the motion. Right.
So do we vote on calling?
We
it
have
out?
to
didn't
vote
hear a
on
second
calling
for
the
that.
question, yes.
I didn't hear a second.
Did you second?
I'll second it, yeah, I don't believe in letting motions
All right,
go
well,
on the floor.
what precisely is the motion?
So he wants to
Motion
go
is
ahead and
that we
move to vote on the
on
motion
the-
that was just
on the-
read.
right now.
Was what he wants to do. We can continue to discuss it if we vote against that motion, or we can just vote on the motion as it was read and move to the next order
Ms.
of
Burns,
business.
did you have some further information that you'd like to give to the
There's
commission?
there's a motion on the floor.
I understand that. All right,
as to the original
Yes.
motion, I did have some
all right.
additional
All right, then we'll proceed. with the-
comments, but there is a motion on.
All right.
Yeah, so we have to handle this motion before we
Right.
go.
All right,
go
the
back.
motion, please repeat the motion.
Please, I call the question.
Call the question.
Which means we would just vote
You vote.
as that was just read,
Mhm.
up or down,
Right.
right? Or if we turn down that motion, then we can go back to discussion of that.
Fine. All those in favor of the motion signify by saying aye.
Okay.
Was that it? I'm sorry.
I'm sorry.
I wasn't voting
Oh.
for that
Okay.
motion.
You did
to
not,
call the
so we
question.
have one
I'd
vote
like
in
to have some
favor of
discussion on
the
it.
treasurer.
Okay.
All opposed?
Aye.
Aye.
Okay.
Motion fails.
Motion
Correct.
fails.
So we will now continue with the
With
discussion.
discussion of
All right.
the primary
Ms.
motion.
Burns, would you please continue with your discussion?
I would, although I believe Reynolds and Williams wanted to be.
I'm sorry, Reynolds, did you have something to add?
No, my request was, since I'm the proponent of the motion, once you finish with the briefing regarding the motion, I'd like to be recognized first, that's all.
Okay.
Okay. As I was saying, we have had discussions back and forth and have tried to ascertain specifically what the concerns are for the refusal to fund the investment. I would note again that a large number of the contracts in the SAE 16 related to State Street have been available since mid-September of 2013. It was only the two final contracts that we actively worked with them to develop that was posted at the end of July to begin the 3-day review period. Historically, when we've had review periods, if treasurer staff has had any questions, they've been proactive about reaching out to us to discuss those. And we got none for this investment. The treasurer did raise a general objection right before the deadline, but again, it was very, frankly, in our view, vague as to what the specifics of the concerns were for us to be able to respond. We have reached out a number of times to discuss it and get clarity. We did have a meeting with his staff, and it was helpful, although the discussion was related to requests regarding certain amendments to the certification of sufficiency that really were just adding RSC Legal certifies in individual spaces on the chart, although it has an overarching one at the beginning. They also wanted some clarity in terms of the name of specific member of the audit or the compliance staff that had actually reviewed the key terms chart and the final contracts to verify whether or not anything had changed, which we did respond to that very night and give them a draft. We also, they had asked for some similar edits to what they had requested on a in-bank fixed income contract, and after we discussed with them that State Street contract had been closed and it was a different type of investment, it was not in bank, so the edits that they had asked for weren't necessarily appropriate, but we offered other detail regarding the contract as to what should give them, we thought, assurance that the treasurer and the bank would receive any and all detail that they could would need. In addition, we offered to ask the chairman to sign a letter to State Street specifying specific additional information that would be reported to the bank on a monthly, each month, and we never got a specific response to that. The questions, frankly, have evolved into more questions about correspondence between the new administrator and managers, which we've been trying to respond to, but again, I'm unclear as to how that's directly related to State Street and any concerns regarding the safety of the funds with State Street. They also have requested some additional information to be provided to the bank on out-of-bank assets so that, in their opinion, the bank can run more detailed reports regarding out-of-bank assets. Again, more of a global question and not specific as to State Street. The last contact that we have had regarding specifics was the letter that we received late Friday, which I believe you all received as well.
Mr. Manning, could you please put that letter up?
Yes.
Yeah.
This is the letter to yourself, Mr. Feinstein.
Yes, sir. There it is. Thank you.
And again, since this came in late on Friday, we've not had a chance to really sit down and discuss our response. I do believe Mr. Feinstein had some initial remarks to make regarding the letter. But at this point, we just felt it was incumbent upon us to bring the matter in front of the full body and seek direction. Because at the end of the day, we are sitting on $1 billion in cash, and the investment needs to be funded, and these issues got to be resolved in some way. And we continue to stand ready and willing to work with your staff, but we just are unclear as to how to move this forward.
Mr. Chairman, may I just a couple of
Yes,
brief remarks
please,
regarding the
go ahead.
treasurer's letter? We thank the treasurer for his August 22nd letter, and as Ms. Byrne indicated, we will need a bit of more time to more carefully review it and then talk to the commission to get guidance about it. Some very preliminary initial notes, however. There are three items in this letter. The first is a request to list the State Street account in the name of the SC State Treasurer as custodian for the benefit of the SC retirement system. Now, that would be not only a very significant departure from the way in which each and every one of the trust fund's investments have been titled to date, but we actually think that, and again, this will have to get looked at more carefully, that the request does not square with state law. South Carolina Code Section 91620C provides, we think quite clearly, that the South Carolina Retirement Systems Group Trust is the owner of all assets of the 5 defined benefit plans. And we also would simply note in a preliminary way that this request does not appear to be in keeping with or consistent with the South Carolina Attorney General's opinion from November of 2011, which seemed very clearly to state that the at that time, it was just the board, the Budget and Control Board, that entity, quote unquote, holds the legal title to such assets on behalf of and in trust for the beneficiaries of the trust. And went on to indicate that the custodian is not, quote, in the category of owner of the public funds, but a mere custodian thereof, close quote, and that the function, the custodian's function is to act as a bailee of those funds and to disperse such funds upon proper warrant or other directive authorized by law. So that's the preliminary response to the first item. The second item mentioned in the Treasurer's August 22nd letter concerns certain language that the Treasurer's Office would like to see added, not only to the State Street contract, but to, it says, all other investment contracts. Our preliminary comment there for you all is that since mid-2012, the staff and council of the commission have, in very good faith, not just attempted, but in succeeded in incorporating in all new investments language which removed any question about the ability of the Treasurer's Office as statutory custodian to obtain access to investment information which STO needs to perform its custodial responsibilities. And the last 2 years have been blessedly free of problems, at least to the best of our knowledge. Neither staff nor council, nor I think any of the commissioners were aware of problems on that score, and we were very happy about that. The third item in the concluding item in the Treasurer's letter expresses some other custodial concerns regarding the State Street investment. And there, Betsy, I turn it back over to you. I mean, I think it's what you said before. We just, how would you wrap it up?
Correct. The reference there, again, was just a very general, we have concerns regarding the safekeeping of the funds because they were not in bank. But again, I mean, we've not been able to clarify what specific information or what the issue is regarding State Street as the custodian for these funds once the funds are in and securities are in the State Street account.
So the motion is before you, and we do hope that the investment will be funded by the Treasurer's Office in short order. If not, council and staff will need to obtain further guidance from the commission. Thank you, Mr. Chairman.
Do you want to see if Reynolds?
Reynolds, did you have something you'd like to add?
Well, the only thing I wanted to say is this is the third time an event like this has come up. And, you know, the commission authorized the investment. The custodian has a ministerial duty to follow the commission's instructions with regard to the group trust funds. And I think it's time to move forward and get that done without any further ado. It's costing us some $18,000 a day to delay this ministerial act, and there's no excuse for it not being done. And so I not only propose the motion, but I now do ask that we call the question. I hope somebody will second it, and I hope it'll pass.
Can we have a little more discussion?
Well, let's have a second, then we'll allow for discussion.
I thought it had already been seconded, that's why we're
I
discussing.
believe it, I'm sorry, I believe it has been seconded.
Yeah.
Okay, yes.
Yeah.
Now is the time for any further discussion.
Yeah, I mean, my only comment, I mean, is, I can't speak to all the particulars of this, which make the motion as written hard to, you know, to vote on as written. However, you know, I think it's a shame something like this even has to make it to the agenda at board level, right? I mean, this really is a staff level policies and procedures, right? We have to be able to function, right? And I say that, you know, just for example, I printed out the operational manual. I interact with custodians every day, dozens of them, right? There's operational, you know, procedural manuals on how we interact. There's conversations every single day on every single product, on every single type of investment. People know how accounts are titled. People know what paperwork is involved. People know what account forms are involved, right? So the fact that this item for an organization this big makes it to the board level is truly a travesty. Now, I have problems with the way this particular motion is written, but, you know, I think it's sad that this is even being discussed at board meeting.
Well, there's a very simple solution to this, Mr. Gillespie, and that's for the Treasurer's staff to sit down with our staff and resolve this so that we don't have the retirees of this state, which number something like 500,000 people, suffering because of the inaction of people who are unwilling to sit down and resolve this matter. It is the retirees of this state that are suffering. It's not me or you or Mr. Loftus that are suffering, it is the retirees. And it's our job to solve it. And I intend to see that it will be solved. Now let's get on with it and get it solved. Does anybody have anything else to say?
No, I mean, some of this gets to my further
I
question.
move-
I mean, can we get an update on what is the status? Because, I mean, act like we can just send directives, right?
Well, what
I
do you
mean,
think the
that's-
status is?
Right.
You've
But-
heard what the
well, just
status
like
is.
operational
Well-
policies and procedures, account title, I mean, literally, like, I mean, I have everything from when a check's received, who handles it, how's it titled, right? How's it recorded? I mean, I don't have a sense for what the operational infrastructure here looks like. I don't understand what the interaction between us and the treasurer's office is, but it's clearly broken down
Well,
and
Mr.
not
Gillespie,
working.
we
Yeah.
do have a procedure where all these documents are presented for review and,
Oh, and can,
and we have a
I guess
3-day
my
review
question is,
period, and
is it
nobody makes a
like every
peep.
time, is every investment treated as if it's something new? Right? Like, there shouldn't be, every time you wanna make an investment, right, there's generally a standard body of account forms, of account titling, of procedures for, is it a collective trust, is it a private equity fund, is it a separate account, you know? And, I mean, what is the operational detail and the extent of it? Because I only say that because in the private sector, right, you have either a clearing agreement or a custodial agreement. I mean, there is a written agreement that says what the two parties are obligated to do, right? And when there's a dispute between those two parties, you go to court and you get it solved, right? Or you choose a different vendor. We don't have that luxury, right? I mean, those are really kind of the
Are you suggesting that every time we have a dispute with the treasurer's office, we should go to court?
No, that's not what I'm saying. I think there ought to be a operational policy manual and procedure between the two organizations. And I don't, you know, from our seats, I can't ascertain the
Well, what if we
status.
can't get an answer?
Well, then I mean, you gotta go to court,
Yeah,
right?
how
What
about
would you do with it?
You know, I happen to be a party of interest here, I'd like to talk. If you're not gonna interrupt me, I'd like to talk.
You have the floor,
Good.
Mr. Chair.
But it's
Mr.
funny that
Treasurer.
after all this important, and I'm behind the staff, no offense, I'm behind everybody on the planet. How do you argue yourself out after you've had a 15 or 20-minute dissertation? Well, let's just start with some of the facts. The state treasurer is the statutory custodian. Now, I see you just, your body language went crazy when I said that. I don't care if you
I'm
like it
so glad you're so
or not.
perceptive, Mr.
Yes,
Treasurer.
I don't care if you
Well,
like it
get
or
on
not.
with it.
Ah, the hell with it.
I move
This
we call the
this is
question.
this is a lawless
Need to
place.
vote on the motion.
This is a lawless place, and you know, I spent hours reading the Supreme Court cases on this, the case on this. I spent hours in all these things. We're just trying to get Mr. Feinstein and Ms. Burns to fill out the paperwork that we gave y'all in 2012, which you haven't done. You talk about the 3-day notice. It doesn't apply to custodian. We need longer than 3 days. We don't have time to look at that. They don't tell you, Alan, this is how they do it. They send me the notice. They quit corresponding with the custodial staff. They send me the notice to trigger the custodian, and they don't tell me. I'm the state treasurer. You gonna send Nikki Haley, say, hey, DSS, something's going on over there, or corrections going on? We manage billions of dollars and lots of programs, and I'm supposed to be the middleman for the email? We missed investments. We didn't even know they closed. The Penn investment, we didn't know it closed, because y'all didn't correspond with these people.
I disagree.
No,
I
that's
have an email.
Or
where I
which
said
one,
that.
which one was it?
They,
Well, we missed one investment, whatever,
but they did correspond, we just missed it.
after the fact.
Before, the pen we did receive, the other
Oh,
investment.
well, then State Street and Pimco, you didn't. And the only reason we even knew about those is because late on a Friday afternoon, I saw one, I said, and I sent the notice to Clarissa or somebody with just a little note, you know, I got this, I don't know why I sent it. I mean, I had no obligation to send the thing. So the system, it goes back to, no man is as blind as one who won't see. It's simple. We get no value out of this. We don't get a nickel for being custodian. And yet it costs us a fortune. We have to work on the weekends. Well, y'all are all on vacation, by the way. We'll work on the weekends because y'all told us that the PIMCO contract was a simple renewal. And it wasn't a renewal. It had changes all through it. So when we found that out on Friday afternoon, we asked for a copy of the red line. We couldn't get it, so we took it home that weekend because we had to read it. We don't have the luxury. Y'all set the schedule up. State Street, y'all had it approved since September of last year.
Right,
September.
correct.
We had no advance notice it was coming to the minute it hit our door. And you didn't tell anybody but me. Now, there's so many things here. There's these false dynamics, like we closed, therefore we have to fund. That's a false dynamic. They put it into a letter to the governor and everybody else, we had to close on the 15th. That was false. It was not true.
Mr. Chairman, does anybody second my motion to call the question and proceed to vote on this?
All right, I'll second your motion, Reynolds.
So don't even get a chance to defend myself.
Well,
Don't even get a
We have-
chance to
we
defend
have-
myself. This place is lawless, and the people of this state should fear for their money, because anybody who treats their money and the laws like this should be feared.
Mr. Chairman, the call of the question.
we have a motion, we have a second, I think.
Let the record say that I tried to speak on several occasions and couldn't, and it was
Mr.
finally
Chairman,
cut
he's
off.
out of order. Can you call him
I
out of
think
order,
that we
please?
will now have a vote. I think we've had enough discussion on this point. So all,
We have to vote on the call to question, then we have to vote on the motion.
This is
could
why
somebody please state where we are?
Yeah, the
So,
motion is to-
we called the question, so we need to vote on calling the question.
On the motion that is up on the screen,
All right,
it's
the
the second
motion
page of
is
your.
the funding of the
Well,
State Street
this
Global.
is calling the question, so,
Calling.
so I'll say all in favor.
All those in favor?
I'm calling the question.
Calling the question?
Aye.
Aye, opposed?
Aye.
So we have, wait, I think that was 3-3.
Well, it sounded like
Reynolds,
Roy
did you
Reynolds.
vote, and were you?
I voted aye.
Okay.
So I think we had
Voted
3-3,
aye.
Yeah,
Aye.
I voted
Is
against
unanimous?
calling the question.
It's 3-0.
and,
No, it's 3-3 tie.
3-3
Okay,
tie.
so that it doesn't.
So
okay,
discussion will-
So we're still in discussion on the
Okay,
primary
so we're
motion.
still in discussion.
Okay.
So,
Well,
let's say a
then
couple things
continue,
here.
Mr. Treasurer.
Well, thank you for the
floor.
permission, Ed. Thank you for the permission. It's funny, I sit with your boss, Nikki Haley, every day at Budget Control Board, and she's never run a meeting like you have.
Oh, really?
Yeah, she's
Well,
never run a meeting like
perhaps
this.
you ought to give her a few suggestions.
Yeah. Okay, so the state treasurer is the specific custodian. Most of those tasks are ministerial. Most of them. Not all of them, but most of them. And we'd like for them all to be ministerial. We don't get paid for it, we don't get employees. We have significant statewide obligations. We have contracts of our own that we can't get done, that cost the state a lot of money, because we're asking the 4 lawyers here versus the 2 lawyers I have, asking them to do the things that I've asked. We sent in 2012, 2 letters. One said we need 7 days at a minimum, but we make 7 days work. And this is the list of things we have to have. We're not getting those things. So that means we have to go into the investments and study the investments. We're not equipped for that. Now, if we'd gotten a courtesy notice saying, hey, I'm making up the day, on Wednesday, you're gonna get the State Street stuff, we could have gone back and reviewed the information that we haven't looked at in a year. Does any lawyer in here think they can remember well enough a contract or agreement from a year before? Rebecca, can you, for a $4 billion contract, can you remember that well enough from the year before that you don't have to go back to it?
I don't know if I can.
Yeah, you can, just trust me on this. So, let's go through the bullet points here. Commission voted unanimously, it's a little bit beside the point here, because I voted for it, love the investment. Been asking for these kinds of investments for a long time. Jim Powers gave me a lecture on this, and I'll listen. Second paragraph, letter of legal sufficiency. That letter is itself not sufficient. And then there's a sentence in there that says the documents are legally sufficient. Legally sufficient to what? To what?
May I ask you a question?
Yes.
I thought we had a long discussion on legal sufficiency, at which time I agree with you that we had to reduce that to a single page, and we agreed to its content.
No.
And then subsequent to that.
Have you read this one?
Have I read what?
Yes.
The revised?
Yeah, the revised one?
Yes.
There's significantly less in there. Things that are left off, not important to the people at this table, things that are left off. We funded this at $2 billion to start with. Our fee is gonna be about half a basis point. our administration fees can be up to 4 basis points, plus fees and expenses on top of that. That's not in there. Did you know that those expenses were there? Did you know that? Did you know that the administration fees were 8 times as much as the management fees, but are not in our documents? Is PIPA concerned that we have those other fees? They're not in your document. You were in here for the investment, but you wouldn't know it. Why wouldn't we have the ability to know what fees we're paying? That's just one of the problems with this. The first documents that came over, and of course, remember, this came on the heels where we have to take home the PIMCO contract. And we're reading them back and forth to our spouses and our friends, trying to figure out what was changed and what wasn't changed. Because they didn't give it. They, one, didn't tell us there were changes, and two, didn't tell us what they were. Then when we asked Mr. Feinstein, he said they were betterments. That's not his job to say it was a betterment. The final authority for investment lies right here. Not staff, right here. But they can change contracts before they come to us. We all get insurance policies at our homes. They come every year, they're the same policy, and if not, they send you an endorsement. They know they have to tell you a change. This staff thinks they don't have to tell you. Well, we're the minister, we're booking this in. We're looking at one and looking at the other. These aren't the same. How can that be? It said it was a simple renewal. We asked about changes, and there were none. So, 3 days to the commission. That's good. Y'all get 3 days. Treasurer needs 7 days to do it. That's just how long it takes. Especially when we have 2 or 3 of them backed up. So, it doesn't apply to us. I said at the time, y'all can pretend it does, but it doesn't help anything. Once, I think it was at 5:18 on a Friday afternoon. Now, I don't know why we executed a contract at 5:18 on a Friday afternoon. But we did. I mean, there's nobody to get to the other side. But once it was executed, are we supposed to keep spending time on it? It's done. There's an email that says there aren't going to be any changes. All we're asking for is the stuff that was in the May 2012 letters. If you go to the September 2013 minutes, you'll see where Derry Oliver said everything's going just great. Because we got those documents. And now we can't get them. What they've started doing is the summary memo, which used to have administrative fees and all these things in it, has less and less. Because they don't, the document of legal sufficiency is no longer the pertinent information and the key facts to the commission. It's what's in that little box. So the box was this big. I'll show you. Grab it, click here. Now it's this big. Now, State Street is a good investment. The fees are just fine. I like them. I know those guys up there. Every day, while y'all are telling me there's a crisis, we got a fund, I'm talking to the other side. They hadn't had a first conversation about a funding date. They said, we've sent them dates. Michael Haley is his name. Nikki Haley's just like Nikki's husband. I talked to him several times during where y'all sending the governor and everybody else letters with these false statements to build a crisis. It's reprehensible. Do you have something in writing saying we were supposed to fund on the 15th?
Mr. Chairman,
Are we done? Are we-
Are we right now?
Well, now I'm not through. So, anyway, so that lack of candor requires us to have a higher degree of professional skepticism. Because what else can we do? I mean, you're holding 2 contracts supposed to be exactly alike, and they're not. You're looking at one, and it's leaving out your fees. Okay. Next paragraph.
Mr. Chairman.
I'm not through. Next paragraph is that the fundings, it says we didn't raise an objection. I would think that we can't fund is the ultimate objection. Now, I could have written some things in there, I suppose, on a Friday afternoon, but who knew they were going to raise it and do it at the contract? But it's the ultimate objection. And to say that it's not an objection or valid when you say you're not going to fund is sophistry. Once we funded, it didn't have to raise. We've had that investment since September ready to go. And for some, we had it saving 2 hours. All this other time, how much money did we lose? What did we not do? I don't know the answer to those questions. Goes back again, 3 days, doesn't go to us. On August 1st, after receiving closing certification, they executed and closed. Didn't have to do either. Didn't have to do either. It was an election, it wouldn't have mattered. Michael Haley would have been more than happy to get on the phone with us and fix these problems. We could have talked to everybody, but we had to race out at 5:18 on a Friday afternoon. Howard, does anybody sign a financial contract on Wall Street at 5:18 on Friday afternoon? In the summertime. The information, the last paragraph on the first page, the information has been here since 2012. We probably erred by not sending it back, but we were kind of proud that all this had worked itself out, and I didn't have to get involved. Because, you know, to start with, I had to read all the documents. That faulty legal interpretation, overly conservative, I believe they call it, required me to read them. Well, I quit reading them. But you know what? I'm reading them again now. And you know what? It's pretty interesting reading. Some of the things that are promised to us aren't in these agreements. And so, you'd have been better off without me looking at them. RSIC talks about losing money. RSIC knew the cost of this when they raced toward closing. When they converted, knowing they weren't going to be funded, RSIC did. I don't know how to say otherwise. There are costs, there's no doubt, but this is politics over finance, and it shouldn't be this way. And during this whole time, not to be a little bit too personal, but I think all of the legal staff here had some kind of vacation. I've canceled all of our vacations because we can't get the work done. The 3 contracts we had back to back to back. Hey, Clarissa's not here right now, she's over the thingy for the RFP for you guys. 8, 9 o'clock every night, Saturdays and Sundays, having to go through this stuff because we no longer can rely on the information that's given to us. So the cost is just there. You talk about we failed to articulate it. We articulated it, and you did it fine for 2 years. You changed the way you present the information to us. I don't know how we get around that. I just don't know how we get that. We can sit down and go word for word with all these things. But it's just the point of the letter of legal sufficiency, which was a long time before I ever came here. Long time before I ever came here, we had the canard of the letter of legal sufficiency, or the statement of it. It's supposed to make sure that we have the information that we need as custodian to book in the investments. And it's supposed to make sure the commissioners get what they promised. Because as Alan, you remember, Peggy, you remember your days? Y'all never see the individual accounting, you never see the final agreements, you never see the amendments to the agreements. So this is the only way we get to book them in at one point. Talk about directing us and the letter of legal sufficiency. I read in Justice Toll, you've got 4 orders. You're very convinced of the appropriateness and the rectitude of the investments and the legalities of it. Wants the skin off your nose if you go ahead and apply. And we're talking about a letter that should probably take 2 hours to do. The other part of this is why wouldn't any responsible custodian get at least some minimum assurance that 500 pages of documents is correct, comports with the vote that's been taken to get assurances about where the money is going to be deposited. And it talks about in civil and the treating of the treasurer in a pejorative sense. Well, not Justice Toll, a different justice. And this is what this is. I come in here, it's all done, everybody's scripted. There's no way to talk about it. Civilton, I came in with a great mood, but when I see this.
Aren't you talking about it now?
I am now, after everybody else has talked, and you've already tried to close the vote. We know what the vote's gonna be before we even start.
Well,
But I just need to put those on the record. I've got a few documents here.
do you have anything further to say?
I think that's about it.
All right. So you have nothing further to add, Mr. Treasurer?
I'd like to add one thing, just because that May 12th meeting was at my request originally, right? And I actually felt like we made pretty good progress back then, coming up with a list of, you know, what are the forms that are gonna be needed, what are the process and policies. I don't know kind of aftermath, how that was ultimately documented. Again, what's the P&T manual look like? I don't know, but it's clearly, whatever it is, it's not working now, but, yeah, I don't think this should be getting back to this level.
After Mr. Oliver left and Mr. Robert came, it went downhill. I just wasn't involved with it. And I get back in there and I start looking at them, I start looking at the contracts and things. So most of it's different.
Mr. Chairman.
Reynolds, you had something you wanted to add. Go ahead.
You know, a lot of those comments are based on the supposition that the treasurer or the custodian has some role in the drafting of or approval of the contracts, apart from his role as a commissioner. And the custodian just does it. The commission has a procedure whereby we vote to approve a contract. Legal staff reviews it, and if the chairman is satisfied that it is legally sufficient and carries out the commission's intention, the chairman is authorized to sign the contract. All of these questions and quibbles and nitpicking should occur during that review period, if at all. And if they haven't occurred during that review period, then they are moot. And from that point forward, the only role of the custodian is to fund the investment as per the directions. After all this work has already been done by other people that would have saved apparently sleepless weekends, etc. It's a simple matter. If the commission decides to make the investment, the documents are contractually sufficient and legally sufficient, and the chairman signs on behalf of the trust fund, then at that point, it should be funded. And if we want a different procedure on the chairman's, and it's not the chairman who signs it, but the vice chairman or the legal staff or some specific commissioner, the commission can vote on that. But our current contractual procedures are for the chairman to sign it at his discretion once he's convinced it's legally sufficient, having heard comments from commissioners who had a duty, if they had a comment, to make it during that period. No such comments were made, and it's time to move on.
Well,
Yeah,
that's the
Reynolds, I mean, can I just make one point? In the real world, you can't just willy-nilly do anything independent of the custodian, right? I mean, custodians do have right and oversight on the investments they choose to custody and procedures and timelines that operationally they can lay out.
May I make a comment here?
Yeah.
The custodian does not have veto power over the investments.
No, they don't.
That's what you're suggesting, Mr.
No,
Bilski.
no,
he's
all right,
not.
go, I don't know where your accounts are held, go try and buy a piece of private real estate in your IRA account and see what happens, right? It's not that you can't get it done, but there's a review period, there's an acceptance, there's capital questions, I mean, there are a lot of questions that flow from that very simple thing that we as a pension might wanna do, go buy a piece of real estate, right? But to act like that, you know, I can just pick any custodian on the planet and go buy a piece of real estate in my IRA account, you can't do it, right? There's laws and procedures and, you know, processes that have to be followed, right? And I think our law does give us the right to make those investments, but pretend like there's not operational procedures that flow through that can impact our ability to implement on our timelines, right? And to implement without considerations from other parties, I think is a false way to look at it. Because that's not how it works in the.
A lawyer-
Well, should I,
a lawyer
let me
from-
just ask our legal team,
Yeah.
because you said we're looking at it falsely. My understanding is that our procedures have not changed and that they have remained the same. And I mean, can you speak to that, Betsy, we are actually following the exact same operational procedures, but we are being asked to do different things, and sometimes the different things are not clear to us, and that is the problem that
Right.
we're facing right now.
Right.
Correct. I mean, certainly for each type of investment, the process may flow depending on the type of investment, if it's an investment management agreement as opposed to a fund where we're gonna have a subdoc, et cetera.
Yeah, and is all that written out, right? I mean, that's what this document here goes through. I mean, whether it's a municipal bond, whether it's a CLO, whether it's a piece
In
of real
terms
estate,
of the
right?
procedure with the treasurer's
Yes.
office,
Yeah, all
the-
parties,
The
all parties.
procedure, the closing procedure that has evolved is the commission votes on an investment. If you approve it, it comes to the legal team. We engage counsel if needed. We work with counsel and the opposing side to draft whatever has to be drafted depending on the type of investment. Once once we and the business folks feel that it is sufficient and we've gotten the terms we need and it's ready to close, then the process that was put into place when Derry Oliver was here is that we draft the closing, or the certification of sufficiency, which is developed in conjunction with the compliance and enterprise risk director, who takes the key terms memo from the memo that was presented by the investment staff when the investment was voted on, and compares that to the final contracts. And he looks at that and says whether or not, as a third party looking at it, outside of the investment or legal staff that was the ones intimately involved in drafting it, whether or not the key terms that are in that key terms box comply with the final contract.
And I'm gonna add to that, during that process, pursuant to another good advance, a collaborative effort on the part of the Treasurer's Office and the folks at the Commission, and with guidance from the trustees, we put in place a mechanism whereby senior members of the Treasurer's Office can now gain, and have been gaining, access to these prospective investments much earlier in the process, so that the custodian staff can do its research, get its questions identified and answered, and not, and be able to say to us at the end of a review period, yep, we're good, we're ready to go.
This is again, there's a lot of information that sounds fine, but if you put a stack of papers, actually in the computer, but they're sitting in the computer, and you haven't looked at them since September of last year. Now, maybe you remember the pharmacy contract we've been talking about a little bit. Maybe you've got that all down pat, and you don't have to go back and look at it, especially after a year. But we're supposed to know it, because when the investment comes, and we had boom, 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 they were right on top of each other, overlapping. We've got to go back and look at this. You are correct, and this is the logic of the investment commission. What was in the investment box or the table summary thing, that's what the letter of legal sufficiency is. It's just you shrank that box. It used to be the length of the time for the investment. If it was a private equity thing, you had that investment period. If it was like with Aronson or something like that, you'd have just the length of the management contract. But all these things, they're shrinking. And now they split key terms to legal terms. And unnamed people do the key terms, and now legal things someplace else. It is not, it should be simple. But you heard the problem here, and it's Reynolds saying that we're nothing but do what we're told. He's a lawyer from Florence. Let me read what the Chief Justice says. Everybody derives their power from the South Carolina Constitution. So you start there, and various people have various roles to play. I don't know that the master servant, is what they were saying, R6 lawyers, talking about their own client, thank you probably. I don't know that the master servant and subordinate and that kind of thing gives us much assistance in analyzing the constitutionality of these responsibilities. And that was a few minutes before she leaned over and pointed her finger at the lawyer and Reynolds and said, the state treasurer is the custodian. He is the fiduciary with discretionary powers. Give the man his information.
Right.
We haven't changed it. You told our staff that you were afraid of liability. I go back to this right here. Did she not say that?
We need one that makes a certification.
Yeah. And so here, it says you got 4 lawyers. You're convinced of the appropriateness and the rectitude of the investment and the legalities. What skin off your nose is it to comply? I had backed away from this. It was supposed to be mechanical. And look, I find out that people weren't even getting notices.
Okay.
And
Well,
so,
suffice to say, we would respectfully disagree with your assessment.
what, did
the
you give us
efforts.
notice, Robert?
I'm sorry?
Did you give us notice? Did you give anybody notice but me? No,
For
and
which
this
one?
again goes to, they don't
Yeah.
believe the custodian has a responsibility. But the custodian does have a
Well, we
responsibility.
would respectfully disagree with your assessment of efforts that have been made by both the Treasurer's Office and RSIC in calendar year 2013 to try to deal with these issues. And a lot of progress
they were
got
fine.
made.
And they were good. We didn't have a problem.
Yeah.
They
Okay.
have changed now.
Yeah, but
All right,
there's
if,
not gonna be a lot
if
of.
there's no further
Well, can I ask just one other question? I mean,
Go ahead.
who's the relationship manager from the treasurer's office, and who's our equivalent over here that talk every day?
They don't talk every day.
They
That's
need
the
to
only
talk
problem we have.
every day,
Yeah.
right?
Yes.
It's pretty simple. I
Yes.
talk with my custodian
That's why-
every day.
Well, there are people that talk every day with, from here with folks at the treasurer's office. A lot of good work gets done every day. I want the commissioners to understand that a lot of vitally important work gets done each and every day by good people working in good faith at the treasurer's office and folks here at the commission. To suggest to the contrary is not correct. But what's happening, unfortunately now with regard to certain specific streams of work, like new investments, the renewals of these IMA, in-bank IMA arrangements, and a couple of other things, we're having some problems again, where, for the last year or two, we had not had problems. But no, good work happens every day. There are a lot of good, hardworking people at STO, a lot of good, hardworking people here, and they make sure the business of the trust fund gets done. I truly hope that the participants and beneficiaries do not come away from today's discussion fearing that business has seized up and has stopped happening. In most respects, it is happening, it is taking place.
It's politics, because otherwise we'd have our 7 days.
I
With
resent
respect-
that
well, I
very
don't
much.
care if you
There
do
is
or
no
not.
politics involved except the politics that you bring up.
Thank you.
There is no room for politics in this commission. Now, let's get that straight. We
Well,
will
thank you
not
very
allow
much.
this
It
commission
is-
to be turned into a forum for a lot of political hot air. End of discussion. Now, is there any more discussion? If there not, we will have a vote on this motion.
Herschel, I'd just like to make,
Do we have a tape of this?
Yes,
I want this to go to Nikki Haley.
fine.
Sorry,
Why
God.
don't you take it over to her personally?
I will.
Okay.
I will.
Good.
This is disgraceful.
if it's okay,
Go
I'd
ahead.
like to make a couple comments. My observation is there's obviously a breakdown on the process that needs to happen to make everybody comfortable, to feel they're fulfilling their duties. With that said, we know that several years ago that we went through the same iteration of discussion of what does a policy or a process need to look like around this. Coming from that, Bill Leidinger and Bill Condon, the treasurer and some other staff members and our staff sat down and went through very exhaustive conversations, many conversations. Results of those meetings was a deliverables list that has become part of our due diligence. And there are a dozen or so things that are requirements, and it's actually labeled the STO checklist items. So the key documents that the treasurer's office has requested to make them feel comfortable that they're getting the information needed to be able to fulfill those duties. That is part of our standard due diligence component to it, and those documents are posted to the Watchdocs system. And they've been there for a while, for State Street. The due diligence report in the memo, we did condense, in fairness, the terms piece up here on the first page, because for separate accounts, it's very different than the hedge fund or private equity. So we wanted to try to get the key features here. But Betsy, please correct me if I'm wrong, but I thought the legal sufficiency not only spoke to the summary table to make the entire document.
The certification, there's two parts. There's the part where Andrew, as compliance and enterprise risk, as a third party, reviews and compares the key terms chart, which is what we understood they were being asked to do to verify that there were no changes between the key terms and the final contract, or if there were, what they were and why. That's what he does, and he provides that data to me or Dory or Robert, and then we feed that into certification. And at the top, we were saying, I, the undersigned, certify to the entire thing. We also certify that the documents as a whole are legally sufficient and ready to close.
Legally sufficient for what?
For closure in terms of terms needed under our state law and in terms of our investment needs to close the documents. And that the key terms chart, which was modified slightly by enterprise risk, because some of the items in there were things that weren't specifically terms that he could certify to. Things like the length of the investment period, because that can be extended, and there were some terms in there that weren't something that he felt he could verify because they could change. So those were taken out of the key terms box, but they're still in the memo. And any additional fees, again, it historically has been the management fees, carry, hurdle rates that have been in the key terms box. Any other fees are disclosed in the memo. They were in there. It's just they had not been, and if the commission wants any and every fee in the key terms box, then we are glad to do that. It's just, you know, we go off the key terms box that we were
They
provided.
used to always have those, didn't they? They had administrative fees on the right, and they would say capped or not capped, and say somebody pays up to the first million, we pay over that, whatever it was.
So the economic terms though, with that said, were on page 20 of 27. So some of the fees, you're talking about the 4 basis points.
Yeah.
And so what I'm hearing is then you would actually like to see the summary table expanded more to be able to pick up some of those things.
Yes, and that was, yeah, I'll say this, yes, we would, because it's the whole, these documents are fluid, because each investment is different, the time frames, and so many things go into it. So we've been very flexible about stuff. There are a lot of times we call over and just find something out and work it ourselves. But if it's in the due diligence, that didn't tell us that it's in the agreement.
Agreed.
And that's the whole point of that letter. I mean, so you got, in the due diligence, there's all sorts of stuff in there. And I'll guarantee you we could go through there and have a real party ripping things out that never came, weren't applicable, for the whole thing. So we're supposed to know what's in the final agreement. See, again, we're back to the point. The point of the letter is it's supposed to take us out of reading these things. We don't want to be involved to look at these things. But we have to, because we can't get the simple information.
May I make a suggestion, Mr. Treasurer? Wouldn't it appear that if we have people here that are reasonably intelligent, on your staff and our staff, that you simply, we can't arrange a meeting and have the two staffs get together and work this out? Doesn't that make sense?
Well, it makes a lot of sense.
Well, then why don't we do it?
Well, I don't know. All of us who send in the information. No man is as blind as one who will see. I
fine.
can't make
Well,
this
then,
place do anything.
I will make this proposal right now, Mr. Treasurer.
Well, good.
That
I'd love for you to
our-
come up. Alan did. Come up and sit in over there.
I'd be very happy to, but I don't think it's my job or your job to get these people to sit down and reasonably work something out. They're intelligent people, I'm sure they can do that.
No, Ed, see, now I gotta cancel my 2-week vacation. I can't get you to come up here for an hour.
Please don't do that.
I've already
Please
had
don't,
2 weeks.
please.
This is my vacation.
You're on
Yeah,
vacation?
and I've canceled their vacations.
Well,
Robin got a half a day off to move, but other than that, everybody's stuck at the office.
Well,
Because
whatever-
we have to do the
All right.
work for this place over here.
Fine, well then, whatever's most convenient for
Yeah.
you and your staff, I would appreciate it greatly.
I'll send you an invitation.
If all of you could get together and sit down and work this out. Now, if you can't work it out, I would be happy to sit there, and you're entitled to come, and I would love to have you come, and we'll make them do it. Right?
The point of it is, people like myself and you aren't supposed to have to be.
Of course not.
But we're down to, let's let our legal sufficiency. Management fee, okay, that's good, but you got that. Hurdle and performance fee, well, they don't apply. So that's two of the six boxes are things that don't apply. I left out the 8 times as much in fees, but that's a whole different thing. We couldn't even get, and I'm not quite sure why, we couldn't even get the legal name of the fund certified. I mean, yeah, it's just, because they're not a legal term listed in the final contract.
Mr. Chernick did not certify that because, as I explained in the box beside that, where I did certify on behalf of the legal department, the contract agreement is actually a participation agreement between the trust funds and State Street. The fund that we're going into is the SSGA MSCI Index Non-Lendable Fund. But the contract kind of sits on top of it, it's the
Yeah, I
vehicle
understand.
for us to go into.
Unfortunately.
So that's why the participation agreement is not a contract for the SSGA MSCI Index Non-Lendable Fund. And that's why Andrew said, well, I can't certify that because it's not a legal term, but that is the fund that the assets will go into, which is what I attempted to explain in the
That's
last
under-
call.
So-
That's under the comments regarding final transaction
documents.
So it sounds like, if I may, it sounds like there might be some misunderstandings about the investment, as well.
No,
And-
we get it. We,
Okay.
listen, we're experts in it. We don't know about it. We've had to read it all.
And it sounds like what you're going through might be the types of things that it would be better if our staff go through as opposed to
No.
do this right now.
Because this
And-
is here.
Yes.
We're gonna go through this, because this is obviously just here to embarrass me. The whole thing is, it's all, we're set, we're right back where we were for the Supreme Court stuff. It's the same exact arguments. We do as we told.
I would take exception to the
Yeah,
fact.
we
that
do
it is
as
an
we're
effort
told.
to embarrass you. It is an
Sure it
effort
is.
to do the best job we can for the retirees in the state to so that the $18,000 a day does not disappear forever. That is the average annual pension for a retiree in the state. Is a travesty that we can't agree to get this done and save them that money. And that's what we should be here to do, and let's do it. So if there's no further discussion, let's have a vote on this. We have a motion and a second, so.
Oh, there was one last question. Where is the legal, where's the statute that you rely, that you can dictate to the state treasurer what he has to do as custodian? I mean, it obviously is exactly, the exact opposite of what Judge Stoll and the other justices said. But where's that statute that says,
That's simply not true.
Yeah, that's not
The
true.
justices didn't make any ruling on that.
well, I didn't
Yeah.
rule, but they, let's read some more.
Well,
Why do we want
Mr.
misinformation?
Mr. Chairman, we can argue
Yeah.
about this.
Yes, and we have an
Yeah.
argument.
And I think that we have an agreement that we need to have the two staffs sit down and reasonably work their differences out.
Yes, but Ed, haven't we
Why
been
can't
there?
we- well,
Haven't we been
Well,
there?
then, I don't know what the answer to this is
Because-
if you're not willing to allow that to
Because
happen.
because I cannot make you understand. It's because we're back to the master-servant relationship. We're back to, y'all know that we said we couldn't do 3 days, but you forced the 3 days, knowing this was gonna happen. I said at the time, does everyone remember? I said, we can't do it in 3 days. You can vote, you
How
can't
much-
tell us what to do.
How much time did you want?
7
You,
days?
you had considerably more than 3 days. Funding didn't need to occur till the 15th.
Well, once the contract was executed and we were told in writing that there would not be changes.
It's the chairman who only has his 3 days.
Anyway.
Well,
Take a vote.
I think it's time that we had a vote. So, all those in favor of the motion, please signify by saying aye. Aye. Opposed?
Aye.
All right, the motion is carried 4 to 2.
And by the way, I might add, that's a great way to build trust and friendship. I have that motion. Okay.
Well, anytime you would like to build that trust, and what was the other thing?
Friendship.
Friendship.
That's all right, Ed. Don't
You
worry
give me a
about it.
call, I'd be very happy to
Everybody in this
oblige.
room knows how the cards lay.
Well-
Everybody knows every single vote,
Curtis, God's will.
and it's always
It's
done
democracy in
as
action.
private. Yes.
All right, now, where are we now? Let's see. Oh, yes, okay, we're now on item 3. I'm sorry, I'm losing a little track here. May I have a motion to go into an executive session to discuss personnel matters pursuant to South Carolina Code Section 30-4-70, parentheses A dash, parentheses 1, and receive advice from legal counsel pursuant to South Carolina Code Section 30-4-70, parentheses A, parentheses 2. Ma'am?
I shall vote.
Okay, do I have a second?
5 seconds.
All right.
Reynolds second. Somebody.
Okay, Motion's been made, and seconded, and we will therefore go.
Well, we gotta vote on
We gotta vote.
I'm sorry, I beg your pardon, I'm a little hazy this morning. All those in favor of going into executive session, please signify by saying aye.
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 Opposed?
Aye.
Oppose,
Okay.
2, 4-2.
All right, so we will now go to executive session, and we will ask
Oh, yeah, we asked, the legal.
the legal staff.
We kinda covered it.
And,
Mr. Walker?
we got everyone here?
No,
Oh,
sorry.
He's gonna
Oh,
run.
okay.
All right, now that we're back in open session, I'm going to ask Mr. Fontaine to read the 2 motions that were developed during the executive session.
Thank you, Mr. Chairman. I'm going to read the 2 motions. There's been a request that the motions be taken up separately. So the first of the 2 motions relates to employment of an executive director. And bear with me, just as a couple of recitals. Whereas after considering the exigencies of the situation, the needs of the organization, the length of time required to conduct a national search, including the benefits of having an executive director in place prior to the start of the next legislative session, the commission believes it is now in the best interests of the trust funds and the commission to implement a solution that will quickly provide stable administrative and operational leadership for the RSIC, and whereas the commission believes that the most optimal solution now is to appoint an executive director without conducting a lengthy search, and whereas the commission believes that Mr. Michael Hitchcock is highly qualified to serve as executive director, and whereas the commission wishes to offer, and Michael Hitchcock has expressed his desire to accept the position of the commission's executive director, now therefore the commission agrees as follows. Number one, any provisions in the governance policies to the contrary notwithstanding, including but not limited to governance policy 1E2, the commission agrees to waive application of its governance policies and to hire Mr. Michael Hitchcock as the executive director at a salary of $230,000 per year, subject to satisfactory completion of RSIC's new employee onboarding process. Number two, Mr. Hitchcock shall assume his duties as executive director no later than September 8, 2014. Number three, the executive director is an at-will employee of the commission. Number four, in accordance with the terms of the commission's compensation policy, the executive director will not be eligible to participate in the performance incentive compensation program. And lastly, the chairman or his designee is hereby authorized to execute any documents and take any actions necessary to implement this directive. That is the first motion. The text of the second motion relates to approval of revisions to the commission's governance policies. That motion, blessedly briefer, is as follows. The commission adopts the amendments as drafted to the commission governance policies as discussed and directs RSIC staff to make 1, the necessary conforming changes to other commission policies and procedures, 2, the necessary conforming changes to incorporate the role of the commission's Human Resources and Compensation Committee, and number 3, technical and formatting revisions to the governance policies. And Mr. Chairman, that is the text of the two motions that were discussed in closed session.
So I think we'll call for a motion on the first, we'll call it the first motion to hire Mr. Hitchcock. May I have that motion?
So moved.
Have a second?
Second.
Any discussion?
I would just like for the record, well, we're voting on the motion to hire Mr. Hitchcock. I mean, again, yeah, as chairman of the audit committee, I just have to say I'm not in favor of waiving policies, particularly for the highest position when one of our primary jobs is set the tone at the top.
There's number 4, it says in accordance with the terms of the commission compensation policy, the executive director will not be eligible to participate in the performance plan. Does that mean that if we change the compensation policy tomorrow, he'll be able to participate in the plan? I mean, we
But
could
you,
just
the
say.
commission would have to set, would have to take action to accept any change to the compensation policy.
Yeah, I mean, but why is it in accordance with that? I mean, why can we not just say the executive director will not be eligible to participate? Because we've got something here that just thinks it's unnecessary.
Oh,
This
is
is where we
that-
could just take the whole bullet point 4 out because it's not.
It removes ambiguity.
Thank you. It was simply intended to remove any ambiguity. Appreciate that.
Is he, you want to take 4?
Well, it's the will of the body.
I mean,
Is everybody in?
I'm fine with it.
I'm fine.
You can leave it in or out.
I'm fine with either way.
Okay.
Only thing, I just.
You just want to make it clear that he's not going to be.
Yeah, well,
Exactly.
in accordance with the terms of the commission compensation, and that means you get 3 votes, and all of a sudden you guys now don't want to salary. Which may be
No.
fine.
No, you need
No.
4 votes.
4 votes.
It would have to count,
Right.
the HR.
It takes 4 votes.
Right.
Okay, well,
You see what I'm getting at? It's just, I mean, this is a,
You're concerned that at some point we might vote to include him in it, Nick?
I'm not concerned about it. It's just either he is or he isn't. And the way we got it is, all they have to do is be, added, to the commission's compensation.
All the commission ever has to do is change the compensation
But
policy.
if it comes from the committee, it comes to the second, it's not organic. Look, I don't care, because you do what you wanna do anyway, but it's just, it doesn't, it's unneeded, it's the kind of language that allows it to change later
What
on.
does legal think?
Just take it out.
No, we could take it out, there's absolutely no problem, Mr. Williams indicated, you know.
All right, so we're removing number 4.
Yeah, okay.
Or just the part before the comma of number 4.
Well,
No, I think
no,
just the
think-
whole,
just-
the whole number 4 is just all extra,
All right, well, then we're moving.
superfluous.
All right, any further discussion?
Well, my only point would be that would then seem to say that they are eligible to pick.
So that's why we were attempting to show that they're not eligible at present.
Aren't we trying to establish that A, he's not eligible?
Yeah,
That's
so
all
why
you
don't we
have
just
to
take out everything before the comma,
Just take out the first clause.
right, of number 4?
So the revised language will be, the executive director will not be eligible
Okay.
to
Yeah.
participate in the performance incentive compensation program. Okay.
All right.
Well, wait, I'm not in favor of that. If we ever change the compensation policy, to make non-investment staff eligible for PIC, does that mean the executive director would be excluded from that?
Well, presumably, we could take future action to make them eligible, Reynolds.
Does it exclude future
Do
action?
what?
I just think we take all of number 4 out.
Yeah.
But it would, by oversight, it would exclude it.
But it would not preclude us
Because this
in
is
the
a
future.
specific resolution that's covering one particular employee, and I don't think we either go have it for all employees of various classes or none of various classes. I don't think we ought to exclude one particular one.
Is he gonna always make the same amount of money? I mean, is he never gonna get a raise? I mean, this doesn't lock us in, it just hires today. And if the commission wants to make such a decision, it ought to make the decision. It can easily be done.
I would guess as long as it does not preclude us from any future.
It would. I mean, we're not ever bound for eternity
Legal,
based on action.
legal satisfied with that?
It would preclude it for now, but you could always.
Right, but
change
it would
down
not
the road.
preclude us in the future.
Yeah.
It would not be organic to this particular position in the future. All right, well, that's fine. I guess that's the answer, Reynolds, that this would not preclude us taking a different action in the future.
Mr. Chair, so could we,
I don't think it does, but it's going to require us to just be careful when we take that action to make sure. Then we'd have to say notwithstanding
Yeah.
the hiring agreement, blah, blah, blah.
Okay.
But we have counsel lawyers, they'll look at that.
Mr. Bannister, did you have something there? Did you have something you wanted
I
to add?
just want to make sure that there is consensus on the part of the members of the commission as to the language that we are going to use. What would you like there to be a fourth item in the motion, yes or no?
Oh. Is it the, do we have to?
I would prefer there be no discussion whatsoever of the compensation plan.
Okay, so strike,
I would
Or
say we
striking
should strike
number
number
4.
4.
Have it the way you originally.
So we strike number 4, is that what?
in
everyone
its
suggested?
entirety, is that the
Strike
consensus?
number 4 in its entirety.
What does it say about like lawyers? Are y'all in the compensation
No,
plan?
no,
Is
sir.
it in your, is it in the contracts? Is it in your employment
It's in
agreements?
the policy.
We don't have, nobody has.
ED does, no.
No, and the comp
People
policy is
have.
very clear that non-investment personnel are not
So the
covered.
COO wouldn't have any language like this?
The COO would what?
Would not have any language similar to this?
The compensation policy is the document that shows who is eligible for the PIC program. I want to make sure I'm answering your
Yeah,
question.
I was just trying to, we've talked way too long about this. But it just doesn't make sense as well, the COO would have it here in a document, and the executive director would, it's okay.
Okay, so strike 4 in its entirety? Is that all right?
Yeah.
Okay.
Is that okay?
Very good,
All right,
thank
so
you.
strike the number 4, so.
Okay.
Everything else remains the same, so,
Mhm.
so we are going to have a separate vote on this, so may, oh yes, we've had a
Motion and
motion and second.
Yeah.
We've had discussion. All those in favor of the motion signify please by saying aye.
Wait a minute, can I discuss this 1 second?
Yes, go ahead.
Yeah, I just wanted to be clear, because some people are trying to make it unclear. I want to make it clear, crystal clear for the public record, that I do not know Mr. Hitchcock. I have not promoted Mr. Hitchcock, and I have not met him. I have complete confidence in the interview process that the chairman and the vice chairman went through in great detail, and I rely on their judgment. And I listened to Mr. Hitchcock carefully during the executive session. I listened to all the questions and answers, and it is my considered judgment that I'm going to vote for him. But I want the record to be crystal clear that I'm voting for him because of what I have learned today, and not because of any preconceived relationship, friendship, or knowledge of Mr. Hitchcock. So I will be voting aye.
All right, all those in favor of the
That's all I
motion?
want to say.
All right, all those in favor of the motion, please signify by saying aye. Aye. And Reynolds, aye. Opposed?
Aye.
Two,
Two.
4 to 2.
The motion is carried, 4 to 2.
There's the second motion,
Would you
Mr. Chairman?
read the second motion?
I can reread that one,
Yeah.
yes. The commission adopts the amendments as drafted to the commission governance policies as discussed. Directs staff to make necessary conforming changes to other commission policies and procedures. Necessary conforming changes to incorporate the role of the HRC committee and technical and formatting revisions to the governance policies.
All right. May I have a motion to approve the,
I move.
second?
I'll second.
Any discussion?
Yeah, again, for the record, I'd just like to say it's not consistent. You know, this amendment to the policies is not consistent with prior practice where it's been distributed well in advance, where comments are solicited well in advance. Again, I find that the joint problem with these resolutions is to make them work, we're having to waive our own policies, right, and procedures, and that's not good practice. So.
Any further comments, discussion? If not, all those in favor of the motion signify by saying aye.
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 Opposed?
Aye.
4 to 2, okay.
Motion is carried.
Mr. Chairman, I think that brings us to item 4, but, Mr. Valesky, did you want to?
Item 4, item 5.
On the agenda,
Yeah.
Yeah.
right? I'd like to make a motion that we carry over the remaining agenda items for a later meeting date, given the late hour.
Is there a second?
Second.
Any discussion? All right, all those in favor of the motion?
Aye.
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 All right, it's unanimous. Then, may I have a,
Adjourn?
may I have a motion to adjourn?
So moved.
Second.
We are
So
adjourned. Thank you, everyone, for coming.
Thank you.